Hello, this is Rocco Beatrice. I'm the Managing Director for Estate Street Partners. Today's subject is irrevocable trust in divorce. Very complicated issue. It centers around the fact that marital assets in a divorce are split 50-50 between the two spouses. If, in fact, the property is held by a third party, it is not marital property, therefore not subject to the split between the divorcing spouses. What is a third party? Well, a third party holder of assets is an irrevocable trust with an independent trustee, and we like to add the trust protector. Assets held by the irrevocable trust are third-party assets. They're not owned by each individual spouse, therefore they're not subject to a division. When do you start planning for a divorce? Well, you start planning before you get married, or you plan with your parents. Your parents is the first place you start if you're contemplating a divorce. You make sure that your parents, when they issue the beneficiary relationship between you and the trust, is that it withholds those assets so it doesn't become a marital asset. You start with your parents. But if it's too late already, can you, during the marriage, create a third-party irrevocable trust as the holder of your assets? Yes, in a lot of circumstances you can. If the assets are originally owned by you, either spouse, and the spouse sets up these assets in an irrevocable trust, over time they don't become assets divisible in divorce. This is Rocco Beatrice. For this article and more, if you want to know more, visit ultratrust.com. Thank you.